You get what's you're ready to begin. Okay. All right, yes, let's bring it in.
All right, for jurors. Oh, this one.
Yes. Thank you. Nothing. Nothing. No. Oh, please be seated. We stand for you. All right, everyone, please be seated. All right, good afternoon. That's some slow reaction time. Good afternoon, everyone. All right. You are in the 187 District Court. It's on the 4th floor, and I am Judge Boyd. So what floor are we on?
4.
And what's the court number?
7.
And who's the judge?
Boy.
Now you're probably asking yourselves, why is she asking us this? Of course, we know where we are. The reason why I always ask that of jurors is because whenever we take a break, everyone must leave the courtroom. And when I say everyone, I mean the jurors. You have to leave the courtroom. And what will always happen when we take a break, someone will leave. And when they leave, what will end up happening is somebody gets lost and we have to send someone to find them. So if you ever look up and everybody's gone, if you remember 187, there's only one 187 District Court in all of Texas. Or if you remember the name Judge Boyd, I'm the only Judge Boyd in the courthouse. So please remember those things. Now, to my left is the court reporter. Cindy, can you raise your hand? All right, thank you. Raise your cards. You have cards in your possession. Raise your card if you want to make her job difficult today. All right, so I'll take that as a no. So then the question, 14, do you want to make her job difficult? Yeah. All right. So I'm taking that as no one here wants to make her job difficult. So how do we not make her job difficult? One, we talk one at a time. We don't talk over each other. And the same tone that I'm speaking to you in, that is the same tone that you need to talk when you are speaking. Is there anyone here who cannot do this? All right. The other thing is, I want you all to raise your cards and lower them when I ask you to lower them. All right, jurors 1 through 21, lower your cards. All right, everyone else, keep your card up. Don't lower your card unless I tell you to lower your card. So, for those of you who still have your card raised, this is what that means. That means whenever you are speaking, if you're physically able to do so, I'm going to need you to stand because that will make Cindy's job easier. Can everyone do that?
Yes.
All right, you can lower your card. I have faith that you can do that, but so far we haven't had a single jury that's been able to follow through and do that. So I'm depending on you all to do that. The other thing, and this goes to the attorneys. Attorneys, when you're speaking to the jurors, please do not block them because when you block them, that makes it more difficult to hear. And for my fellow glass wearers, we all know that it is easiest for us to hear when we actually can see people. So don't block anyone. So this case that you're here for today is the state of Texas versus Robert Quiones. For the state, if you can introduce yourselves, please.
Good afternoon, everyone. I'm Brandon Prater from the state.
Good afternoon, my name is Lauren Espinoza, and I also represent the state of Texas.
All right, in defense, if you can introduce yourself and let your client introduce himself.
Robert Mauer. Afternoon, I'm Trey Mauer. I'm Robert King, the Oklahoma.
All right, so you all have been introduced to the parties. Please raise your card if you recognize or know any of those parties that have just introduced themselves to you. Do you recognize anyone? Sir, what's your number?
21.
20. Do you recognize any of them?
Yes.
All right, the parties who just introduced themselves, you recognize them? All right, thank you. And when you say them, you mean the state? Oh, everyone. All right, thank you. Do you have any bad opinions about any of them? All right. That's good. All right. The charge in this case is unlawful possession of a firearm by a felon. I'm going to talk to you about that a little as I go through my voir dire with you. Then both parties will have a chance to speak to you as well. They will each have 30 minutes to talk to you. Now, when I speak to you and when the state and the defense speaks to you, they're going to be speaking to you in hypotheticals. They are not allowed to tell you what they think this case is about or what they think the facts are in the case. Does everyone understand? So do not do a Mrs. Kravitz on me and start saying, oh, those are the facts. Neither person is allowed to tell you what they think the facts are. Now, an indictment. What is an indictment? An indictment is, in felony court, it's a piece of paper. That's all it is. It's a piece of paper to tell somebody what they're being accused of, which means what they're charged with, and where they need to appear. Does everyone understand? An indictment is not evidence of anything. For example, we're going to practice raising our cards. Raise your card if you've ever had a traffic ticket. All right, this is one of the worst driving groups that we have had. So, okay, you can lower your cards. I've had a traffic ticket before in my life, one. I was probably just out of my teens or still in my teens. And here I am 22 and it's like it happened yesterday. So when you get a traffic ticket, and from my experience, when I got a traffic ticket, the officer will pull you over. And back in the day, they had carbon copies. And I know young people probably don't know about the carbon copies. So they would come to you And they would write and give you a ticket. Here you go. Well, let's hypothetically say that you get pulled over by an officer and they give you a ticket and they say that you ran a red light. Now I think they do it electronically or something and it prints out to give it to you. When you accept that ticket from that officer, you're not saying, you know what, you're correct. I did run the red light. The only thing that ticket is telling you is like, hey, somebody's accusing you of running a red light. This is where you need to be to address that issue. And usually it's downtown on Frio Street or somewhere else where you go. And so that ticket that that officer giving you is putting you on notice of what you're accused of. It would be strange if you were to go to municipal court and you're like, yeah, I'm ready because I know I didn't run a red light. Let's do this trial. And then you're in the middle of the trial and they're like, surprise. You're actually here for failing to yield. So when you think about indictments, it's the same thing as any ticket, anything that somebody's accusing you of. It's an accusation, but you cannot hold it against someone because they've been indicted, because an indictment is not evidence of anything. Does everyone understand? Is there anyone here who's going to hold it against Mr. Keonis because he's here under indictment? If you are, raise your heart. All right, now the next thing I want to talk to you is about the right to remain silent. How many people have seen Paper Chase, The Practice, Beretta, Mannix, Barnaby Jones? All right, thank you. Other people are trying to be number shy. I see you 29. I know you've seen Beretta and Mannix. All right, so the right to remain silent. What does that really mean? That means if you're charged with a criminal offense, you don't have to testify. And the reason why they do that is because the state must prove their case. The defense doesn't have to prove anything. So the state can't say, oh, by the way, we're calling the person who's accused. That's not the way it works. Nobody in a criminal case who's accused has to testify if they choose not to. Now, I've been a defense attorney, I've been a prosecutor. There are many reasons why maybe somebody doesn't want to testify. I've had clients as a defense attorney where I'm like, you know what? You are sweating in my office and I'm for you. You just would not be a good witness. Then you have some people who are extremely shy. Then you have some people who have speech impediments. There are a whole host of reasons why somebody would choose not to testify. And I always chuckle inside when jurors will say, well, if that was me, I would want to tell my story, right? And I chuckle inside because I'm always thinking, yeah, it's not you, and you don't have an expert in the form of an attorney telling you what's in your best interest. And sometimes attorneys will tell clients, the state didn't prove their case. There's no reason for you to testify. So there are a host of reasons why somebody would not testify. It's sort of like when you go see the doctor and they tell you, we're going to have to do heart surgery, and maybe you'll get a second opinion or a third opinion, and that doctor's like, yeah, you need to have this heart surgery done. You don't start telling that doctor, well, I would like you to use scalpel number 2, and then I want you to go in and do this. You listen to their expert opinion. And that's usually what happens in criminal cases as well. Does everyone understand? So the key about the right to remain silent is that's constitutional. So is there anyone here who's going to hold it against Mr. Keonis if he decides, you know what, I'm not going to testify? You're not allowed to hold it against him, but if you are going to hold it against him, please let us know. All right, I'm going to take that as a no. Now, presumption of innocence. What does that really mean? It means exactly what it says. Everyone who has a criminal charge is presumed to be innocent. So, what does that really mean in criminal cases? That means that Mr. Keonis, if you were asked right now, is he guilty or not guilty? What should your verdict be? I can't hear you. And the reason why is because he's presumed to be innocent and you haven't heard anything in this case. So what does that mean? That means that the defense does not have to prove anything. And this is what they would tell us in law school. And I will tell you, everybody who's a practicing attorney, doesn't matter if you're a prosecutor or defense attorney, this is what they always tell you in law school. You do not have to prove anything. if you're representing your client in a criminal case. They said, you can go to sleep. You can play crossword puzzles or video games with your client while the state is doing whatever they do. The reason why our professors would tell us that because they wanted to stress to us that the defense does not have to prove anything. If you are ever deliberating on a jury, and all things being equal, and you're back there and you're saying, you know what, the defense didn't prove anything to us. In many cases, the defense is not required to prove anything. The burden rests with the state and it never shifts to the defense. Does everyone understand? Now, the state has to prove each and every element of their case. So they have to prove it happened in Bexar County. You know why? Because we're in Bexar County. If it's something that's supposed to happen in Harris or wherever it may be, then we should not be here because the jurisdiction for this court is Bexar County. So they have to prove that. They have to prove the on and about date. Every element they have to prove beyond a reasonable doubt. What's the definition of beyond reasonable doubt? When I was in law school, you had to know the definitions forwards and backwards. I knew the definition. I still know the definition. I knew where to put my comma, my explanation point. I knew where to pause for dramatic effect. And then guess what? After I tried my first case, there's no longer a definition for proof beyond a reasonable doubt. So the state won't be able to tell you what it is, and the defense will not be able to tell you what it is because there's no definition anymore for proof beyond a reasonable doubt. So I would always ask myself as a defense attorney and a prosecutor, then what do I tell jurors? They are usually not attorneys. So how do I explain this to them? By telling them what it's not. So next door, you have the historic courthouse, has the green rooftop. They try civil cases over there. Their burden of proof over there, one, is preponderance of the evidence. More likely than not, something happened. So if you are ever on a criminal case, it doesn't matter if it's in misdemeanor court, felony court, wherever it may be. If it's a criminal case and you are deliberating and you are saying to yourself in the back, more likely than not, something happened, you need to remind yourself, wait a minute, I think I'm in the civil courthouse. I am not. I'm the criminal side. I'm at the wrong burden of proof. The other burden they have over there is something called clear and convincing evidence. Clear and convincing evidence is the highest burden that they have on the civil side. That burden is what they use to terminate your parental rights, where they say, we think you're a danger to this child, so you can no longer be a parent to that child. You would think that's a very high burden if they're taking away my parental rights. Well, guess what? Proof beyond a reasonable doubt is even a higher burden than that. So in this criminal case, the state has to prove each and every element beyond a reasonable doubt. Now, I want to talk to you about the word fairness. In jury trials, people will ask you, you can't be fair in this case. This is really not a case for you, is it? Let me just tell you what fairness really means. Let's say this morning you're called up for jury duty and you've planned your route. You know you're going to be here at 8 a.m., even though I see you all running across the street and I say, no, there's no need to run. We're not really starting at 8 a.m. But the night before, you mapped out your route. You said, you know what, I want to map it out because they're doing a lot of construction. I want to see where I'm supposed to be parking. So you do all of that to get ready. You get up extra early this morning. You prepare your breakfast. You got a smile on your face because you're coming to do your civic duty and you're invigorated by that. And when you get downstairs and open your door, the birds are chirping, the temperature is great, you smell flowers in the air, springtime is upon us, and you have your keys and you're just like, hey. And you get to your vehicle and your vehicle is on cinder blocks. Somebody has just stripped it. Now you still have your civic duty to do. So you say, you know what? I'll call the police. When I come back, let me get an Uber or Lyft or take the Via or either ask my next door neighbor. You come downtown, you're just whistling while you get to the jury duty. You're being patient. And then you're on this panel, and I tell you the case you're going to hear is a burglary of a vehicle case. And usually people say, your car was just burglarized. This is not the proper case for you. You can't be fair. Let me just tell you what the appropriate question is. The appropriate question is not your setting aside that you've had some trauma because your car has been stripped. The question becomes, if you were selected to be on that jury, would you be able to listen to whatever evidence is presented to you? And if you can come to a decision, base your decision upon the evidence that's presented to you, not the fact that your car was stripped. Does everyone understand? And I always tell people this. How many people were born yesterday that's on this panel? How many people, even though they were born yesterday, slept all last night? Nobody. Everybody, I have yet to run across anybody that does not have any type of trauma or something that happened in their past that's bad. Even Pepe Longstocking had issues. So this case, unlawful possession of a firearm by a felon. So let me just tell you what that means the state has to prove. The state first has to prove that somebody's a felon, right? So you have to see if they're able to prove that beyond a reasonable doubt. Does everyone understand? Then they have to prove that somebody's in possession of a weapon. Then they have to prove that somebody's unlawfully possessing of a weapon. Does everybody understand? So this case is unlawful possession of a firearm by a felon. Is there anyone here who cannot be fair and would not be able to sit and listen to whatever evidence that's presented to you? All right. Now, the next thing I want to talk to you about is there are two phases to any jury trial on the criminal side. The first phase, people call it the innocence phase, but it's really not the innocence phase. The first phase is, did the state prove their case beyond a reasonable doubt or not? That's what phase one is. It's really not, is somebody innocent or not? It's, did the state prove their case beyond a reasonable doubt? Does everyone understand? Now, if your answer to the first question is no, then your verdict should be not guilty because the state didn't prove their case beyond a reasonable doubt. If your answer is yes, then that means your verdict is guilty. And then you go to the next phase. And the next phase is what's called the punishment phase. That's where you decide what is appropriate punishment. In the criminal law system, anyone who's charged with a criminal offense, they must make a decision on whether or not, if they were found guilty, would they want the jury to determine their punishment or the court to determine their punishment, which means the judge. They must make that election or selection before jury is selected. Does everyone understand? So in this case, Mr. Kianis has decided that if he were found guilty, he would come to the court for punishment. Is there anyone here who's saying, you know what, I don't appreciate that he did that. If I hear a case, I want to decide the punishment if I get to that. Is there anyone here who feels that way? Is there anyone here who's going to hold it against Mr. Kianis because he's followed the rules and he's decided that if he were found guilty, he would come to the court for punishment? All right, the next thing I want to talk to you about is languages. I love languages. I wasn't supposed to be in San Antonio. I'm originally from Louisiana, and you can tell when I have to say words like all and soul. So as you can imagine, even though my friend in school said, Stephanie, let's take Spanish. And my response to her, absolutely not. I'm never going to use Spanish. I'm going to be retired by the time I'm 22. I'm living in Paris. So here I am, 23. I'm not retired and I'm not living in Paris. So what I can tell you is when I went to undergrad, grad school, and law school, depending on where people were coming from, they spoke so many different languages. I can probably say hurry up in every language. For some reason, I was able to pick that up for them. So I can say hurry up in Navajo, Chinese, Vietnamese, Spanish, French, of course. And so some of the people I knew I was just so in awe. I think languages are so beautiful. But for this question, I need you to raise your card if English is not your first language. Oh, don't be shy. Raise your card. If English is, I know there's more than two people where English is not their first. Don't be shy. This is for you all to start answering. So 6, 7, who else? 45. Okay, I find that so hard to believe. Usually we have Filipino, everything. All right, juror number 6, what's your first language?
Spanish.
All right. Have you been able to understand everything?
Yes.
7,
Portuguese.
how do you say hurry up in Portuguese?
Vai
I'm sorry?
rápido.
Oh, I like it.
Okay.
So have you been able to understand everything? All right, juror number 45, please don't disappoint me by sitting. 45, have 45 stand. Yes, what's your first language?
Spanish.
Have you been able to understand everything? How long have you been here? Where did you go to school? I'm sorry, what?
4 years.
4 years school? Okay. Is that here in the United States? All right, thank you. All right, now, I expect this case to be concluded by tomorrow. So, Wednesday, this case will probably be concluded. So, and we will start with testimony tomorrow morning at 9. So y'all know this case will probably be concluded on Wednesday, at the latest Thursday morning. That's the time of this potential trial. So is there anyone who has any time constraints for that? Usually people want to share things like, I'm going to Hawaii 3 months time. So if they want to make us jealous, they can. So raise your card if you have any time constraints. 6, 14, 18, 22, 24, and the person, your card is turned backwards. 33. Oh, and once I call your number, you can lower your card. 54, 64, 72, and 70. All right, number 6, what's your time constraint?
Our thoughts for research symposium.
I'm sorry, for what?
A research symposium.
A research symposium. What are you researching?
I'm detecting credit card skimmers. I'm a computer science major, so I also have a background in criminal justice.
Mhm.
So I'm going to be presenting my work that I found how to detect.
Oh, you're a presenter.
Yeah.
You should have led with that.
Yeah. Yeah.
What time are you presenting?
It's going to be taking place all day tomorrow, so I think I have to be in Austin by 9.
9 a.m.?
Yes.
Okay. Number 14,
That conference.
conference in Austin?
No.
Where?
It's a virtual. Cybersecurity.
Virtual cybersecurity. You should speak with juror number 6. And what time is your virtual cybersecurity? All right. Number 18.
I have something for my job. I work in healthcare, so they're making you a course. Starts at.
CPR. All right. Number 22. All right. Thank you. And it's going to go fine. We're going to claim that. All right. Number 24.
In traffic control on barricades. I do have a job up either 10 or probably 9 o'clock for flagging over there in Catcherville.
All right. Thank you. Number 33.
I'll be representing a client in Guadalupe County District Court on with Taylor.
And you say representing a client?
Yeah.
And what do you do?
I'm an attorney.
Oh, what type of law do you practice?
Yeah.
Okay. And what's the burden of proof over there?
Yan. No.
Oh.
Well, Irfan, yeah.
Yes, all right, thank you. Number 54, so you have twins and a 1 and a 3-year-old? You have an exciting household. Thank you.
The only one that I have.
Okay, all right, thank you. Number 64,
Small business owner, I have some obligations, weekly obligations with multiple clients that I. Practical obligations I can't get out of that.
what contract, I mean, what's your obligation?
Well, I have an obligation to provide real estate research, and I present the amount of research that I have to provide to each client.
Mhm.
And I could go into more detail, but it's I'm trying to be concise.
All right, thank you. Number 70,
My son has a medical appointment at 1:00.
all right, and there's no one else to take him?
Plus his mother's able to get leave approved from
Okay.
her boss, but he won't even approve leave for her own appointments.
Oh, okay. I asked these questions so that the record can be clear, okay? All right, number 72. Oh, thank you, 72.
Yes.
Number 51. Yes.
Oh. Sorry. So you have a prospect like on the right hand side, I am a golden maple tea. It's very difficult for me to be able to sit long hours. No, I did not want to reschedule. I thought since I was already here, I might as well try and see.
Mhm.
And also I find it very difficult to get rights to come all the way over here. So I do apologize. Something will work out. That's great.
All right, thank you so much for letting us know. All right, so this is what I want to tell you all about employment. And I always tell people this. And I use this example that other judges, when I was a defense attorney, used. And I find it to be very true. He would always say, when people said, well, I have to be at work and I have this job I have to do. And he would say, are you indispensable? And people say, yes, I am indispensable. And so then you know what the follow-up is? So what that means is if you ever retire, that job would just cease to exist because there's no one else that can do that. If that's the answer, then you're truly indispensable. If that's not the answer, you're not indispensable. So I'm going to tell you all 2 stories, and both of these stories are true. First off, jury duty is an inconvenience. And the reason why I say it's an inconvenience, because you have to drive downtown. Then you have to pay for parking. And you're like, I'm doing you all a favor. Why do I have to pay for parking? And then you have to hurry up and wait. That's inconvenient. But this is the United States. We cannot have jury trials if we don't have jurors. And I always see people, 4th of July, waving flags, marching for the soldiers, waving flags. We don't even have a draft. Your government only asks 2 things of you: serve on a jury once in a blue moon and pay your taxes. That's all your country asks of you. Raise your hand if you have ever served on a jury and actually heard evidence in a trial. Oh, you need to raise your card. So that's 5, 17, 22, 32. Lower your card when I call your number. 44, 43, 46, 50, 64, 68, 67, 70, and 65. Of those of you who raised your card, raise your card if the trial you sat on was a criminal trial. So that's 5, 17, 32. Once I call your card, you can lower it. 44, 46, 64, 68. All right, 65, you're late to the party. Okay, 65 and 70. All right, of those who raised your card saying that it was a criminal trial, raise your card if that happened in Bexar County. That's 5, 32, 44, 46, 68, 70, and 65. Now, of all of you who raised your card, raise your card if you decided punishment in that case. All right, that's 46 and 50.
Question,
Yes,
does that mean that I would help with the decisions?
yes. That's 32. All right. So, as I said, this is not a sacrifice, it's an inconvenience because when you're called up once in a blue moon. Now, this is what I tell people is a sacrifice. My family grew up in a small town called Grand Cane, Louisiana. My uncle was super intelligent, and the teachers would tell my grandmother, they'd say, Miss Lane, we've taught him all we can teach him. And they would send him to the next grade. Well, when his sisters and brother came after him, they were a little bit disappointed in him because the teachers told them, this is the gold standard and so much is going to be expected of you. So my uncle ends up graduating, and there's a war that breaks out called the Vietnam War. He goes to my grandmother and asks for her to sign for him because he's like, with civil rights and things not going well, there's no way to improve my lot in life here. And my uncle was super intelligent. He knew about computers and the coming thing, as I call it, before anybody else did. So that's a sacrifice because she's sending her firstborn off to some place that people had never heard of until this conflict happened. And that's back in the day for the young people. My grandmother did have a television set. It only had 3 stations, ABC, CBS, and NBC. And in NBC, if there were a slight breeze, you're not going to get NBC. It's going to be a lot of static. You're just in the rabbit ears, putting tin foil on it, no help whatsoever. And when people say, oh my gosh, there's nothing to watch on TV, even though they have 200 and something channels. At some point, programming would end. So young people, what does that mean? That means you can stay up and watch television. You're just going to watch the breeze with the flag blowing in the wind, because once they played the national anthem, that's it. You wait till the next morning to see what else was coming on. My grandmother did have a phone, but it had no numbers. You would pick it up, the operator would answer, and you would tell the operator what you would want. That's why you had those songs like Beechwood 45789, because who would you like to speak to? Oh, I would like Beechwood 45789. Now, you can always tell the era that people are born in by looking at their index finger. If you look at my index finger on my right hand, it's ruined. Why? Because of the rotary. When you're trying to win radio prizes and it was so great when you got touch tone. So my grandmother, when my uncle was shipped off, and a lot of the males in my family are in the military, wherever you get shipped to, time when your boots hit the ground, they make you write a letter to whoever your loved one is. And so my grandmother had his name, she had his number, and she would write letters to him. My grandmother had a 6th grade education, but she was super intelligent. She would babysit me when my mom was at work. I already knew how to read by the time I went to school, how to tell time, real time, not this digital thing that young people are doing now, like the clock that's on the wall. How to answer the phone. how to tell the insurance person who knocked on the door, no, thank you, we don't want any. I did say yes to the encyclopedias and the childcraft books, which I still have them. So my grandmother quickly learned you do not want people in dress uniform knocking on your door because that wasn't good news. I would always end this story here. Then the deputy's like, Judge, you got to tell people what happened to your uncle. We all want to know. So my grandmother did get a knock on her door. My uncle, however, did survive. He continued in the military. And I will tell you, he would come home, visit me, visit my mom, my grandmother, and he would always hug me and have a gift for me. And that is why whenever I smell Old Spice, memories just come flooding back because everybody in the military, or time when you got to be 18, if you were a guy, you're putting on the Old Spice. But he's since passed, and some of the sisters have since passed. But I tell people that story to let them know this is just an inconvenience. It's not you sending your firstborn off to the military, not knowing what's going to happen. It's an inconvenience that your country is asking for you so that we can have a criminal justice system. The next story I'm going to tell you is about a friend I went to law school with. She decided to practice civil law. I decided to practice criminal law. And she said, hey, let's do lunch because I'm going to have jury duty. I'm like, great. And it was like time had not passed. And we're sitting there and I ask her, how is jury selection going? She tells me it's going great. How is this possible? What do you mean? And she said, it's like when we were in law school. I'm on the back row. I'm keeping my head down, so I'm not going to be on this jury. I started laughing. She said, what's so funny? I said, you are so going to be on this jury. So other than raising your card and saying to all parties here, please place me on this jury. The other way to get placed on this jury is not talking at all. Each party is going to have 30 minutes to speak to you. They're not going to be able to go to your house, have dinner with you, and have conversations with you and spend the day. They only have 30 minutes to speak to you. So please talk to them. Both parties want to have jurors who are going to sit and listen to the evidence that's presented to them. And if they can come to a decision, come to a decision. Does everyone understand? All right, before I turn it over to the state, any juror or anyone needs a break? All right, state, you may proceed.
Thank you, Judge. And Judge, may I have a 5-minute warning?
Yes.
Thank you. Good afternoon, everybody. Good afternoon. Yeah, I feel it too. I had a nice lunch and I'm really ready to get right now because, oh my goodness, I should have drank that second cup of coffee. But I'm gonna try and be lively for y'all so I can educate y'all on what this is and talk with y'all, figure out what your opinion is on things so we can get a fair and impartial jury. Everybody cool with that? Okay, so real quick, let me introduce myself. My name is Brandon Frater. I'm a prosecutor with Berry County DA's office. Let's see, before that, I was actually a defense attorney sitting over at this table. Before that, I was actually a deputy wearing that uniform over there. And before that, oh, that's college, high school, grade school, all that stuff. So, helping me out on this is Ms. Lauren Espinosa. We've done a couple of trials together. She's a wonderful person to work with. On the defense side is Robert Maurer and Trey Maurer. They're both, you're not gonna hear prosecutors say this usually, but these are really good defense attorneys. They have my respect. I usually tell defense attorneys when we go to trial, it's like, hey, it's like a boxing match. We come together, we touch gloves, we're gonna get some shots in left and right, but at the end of the day, we shake hands and like keep professional. So I can be professional with these gentlemen. They're good attorneys. Listen to them because I will be listening to them. All right. All right, so let's get straight into it. Why are we here? Well, as Jeb said, the offense that we're going to trial on today is unlawful possession of a firearm. The quick and dirty on it is from 4604A of the Texas Penal Code. Basically, a person who has been convicted of a felony commits an offense if he possesses a firearm after conviction and before the 5th anniversary of release from confinement. So this is our burden. This is from the indictment. On or about April 12, 2025, in Berry County, Texas, Robert Quinones possessed a firearm after being convicted of a felony, to wit, unauthorized use of a motor vehicle, and possessed a firearm within 5 years of being released from confinement.
So this is gonna be my first question to y'all, and it's a scale question, so. Nonviolent, who agrees and who disagrees with this statement? Nonviolent felons should not be allowed to have firearms. If you feel like you're in group number one, which is strongly disagree with this, that nonviolent felons should be allowed to have firearms, raise your card right now. All right, so in the one category, I have 8, I have 10, I have 14, 13. Drew number 7, are you holding it up?
You're asking for what?
Oh yeah, for number 1, who strongly disagrees that nonviolent felons should not be allowed to have firearms? Disagree? Okay, so 14, thank you, sir. 17, 20 and 21, 24 and 25, 28, thank you, 32, 42 and 43, 57, thank you so much, ma'am, 65, and 75. Okay, thank you. What's your first? It's flipped around. There we go. Okay, thank you. You'd be surprised how many get hold upside down as well.
Right.
Absolutely.
I guess I'm reading it wrong. So what we're saying is that they should not be allowed to have firearms.
Yeah, you're disagreeing with the idea that a nonviolent felon should not be allowed to have a firearm. Okay.
But one is.
It's a couple of double negatives.
Yeah.
Yeah, let's start the other way around then. Who strongly agrees with this, that a nonviolent felon should not have a firearm? Who agrees with that?
All right, let me pause it for a moment.
Of course.
State Defense, can you all come forward? And Cindy, we're not on that.
Let's say that there is a man who. He's been convicted of murder twice. Like he murdered one person, then he murdered another person. Who here is okay with that kind of person possessing a firearm? Thank God. Okay. Okay, you're okay. What's your juror number, sir? I didn't see it was flipped around. 10. Thank you so much for that. Does anyone agree Okay, let's do another hypothetical. Let's say that we have, so in the state of Texas, meth possession or having way too much marijuana in certain amounts can be considered a felony. A guy gets arrested for that. Who here would be okay with that kind of person, with just drug felonies?
All right, no, the objection will be sustained.
So basically, guys, what I'm asking is we're talking about the hypothetical with the guy with 2 murders. This one is about non-violent felons. So who would agree with this statement that a non-violent felon should not be allowed to possess or have a firearm? Show your cards. If you agree they should not have a firearm.
I'm gonna object again as commitment question.
All right, that objection will be overruled.
Thank you. Could you hold them up, guys? Okay,
Wrongly or at all?
I'm sorry.
Now, you're asking a different question because before you were asking us to evaluate that question on a scale. Now you're asking to evaluate it apparently on an absolute.
Yeah, now we're gonna break it down to you either agree or disagree. So I apologize, guys, that's formatting error on my part. So, the people who are holding up their cards that would agree with this statement. So that's gonna be number 2, thank you. 6 and 7, thank you. 12, thank you, ma'am. 16, 21, 22, 29. Don't go lunch first one. 32, 37 and 38. 40 and 41. 44. 48 and 49, thank you. 51, 52, 53, 54, 55, 56. 61, 69, 70, 71, 73, and 74. Okay, so let's flip it over to the other side. Who would disagree with this statement? So I'm seeing 1, 3 and 4, 8, 9, 10, 11, thank y'all. 13, 14, 15, 17, 18, 20, thank you, sir. 24, 25, 26, 27, 28, 33, thank you, ma'am. 34, 35, 36, 42 and 43, 45, 46, 47, 50, thank you, ma'am. 57, 58, 59, 60, 62 and 63, 65, 66, 67, 72, and 75. Okay, thank you guys, appreciate it. Now let's move on. So part of that burden that I showed y'all was intentionally versus knowingly. What does that mean? So a person acts intentionally or with intent with respect to the result of their conduct when it is their conscious objective or desire to cause the result. Let's say that after this, the trial goes bad, Lauren's very mad at me, and she says, how could you get another case on my losing record, Brandon? Points a gun at me and shoots, bam! Did she intend to do that? Exactly. It is her conscious objectives or desire to cause the result. She knew what she was doing, and she took actions to do it. That makes sense? All right, next one, knowingly. Person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the same result. very precise things in the law. And it's kind of like a recipe versus directions. I was gonna talk about like a recipe to use waffles, but to be honest, my wife is the cook. I am not. I burn water. It's a curse that I have. So it's kind of like making a peanut butter and jelly sandwich, because I can make that. Like you have to have, in order to make a peanut butter and jelly sandwich, you have to have peanut butter, you have to have jelly, and you have to have the bread. You have to have all of those items together. If it was peanut butter or jelly or bread, we're gonna have this weird deconstructed pile of bread, glob of peanut butter, and then a glob of jelly on the side. It doesn't make sense. It's the recipe where it needs everything together or not at all. Or it's kind of like directions. Like you come up to a stop sign, you can take a left, you can take a right, or you go straight. Can you take a left, a right, and a straight all at the same time? I mean, maybe in some like weird quantum worlds, you can possibly do that. But no, it's not gonna be possible. You gotta have one or you gotta have the other. You can't have them all. And here, care or custody or control or management. We just need to prove one of those to show possession. Does that work for everybody? All right. So what are some examples of care, custody, control, or management? Well, let's go to who drove here today? Okay, that's what I thought. So, everybody here, y'all drive your cars, SUVs, trucks over here? Okay, that vehicle that y'all got, y'all put gas in it? Y'all keep it clean? And make sure the oil's changed? That sounds a lot like care, doesn't it? What about custody? Like, I'm still doing payments on mine, but the car is in my control. It's under my name, the bank still got it, but it's my legal car, it's mine, right? That sounds a lot like custody, don't it?
May I approach?
Yes.
Or on people who drove here, who has their cards? Okay, do me a favor, hold on right now. Hold on.
Judge, may I approach?
Yes.
I'm gonna.
Let's talk about ownership versus possession. If
Judge, may I approach? Based upon the court's ruling that the court have the state take down that PowerPoint. It just will.
yeah, I'll move on, Judge. I'll move on. Okay. Well, let me ask y'all, when it comes to care, custody, control, or management, what are some things that y'all would think of? Or that y'all would need to be able to see in order to say that someone is in care, custody, control, or management environment? Like, what would y'all be looking for? Is there anything off the top of your head?
Video.
Video, okay. What about and driving? Yeah, like if someone was driving a vehicle, that's a possible factor to consider. What else? Like it could be not just a car, but like any item. Like if you're in possession of like your wallet or your keys or your house. Yes. Yeah.
All right, so pause for a moment. So everyone, remember, the court reporter has to take down the record. And if she cannot hear you all, then it's not on the record. And when y'all are speaking, please raise your card so that the record can be clear of who is speaking. And please remember to stand. All right, you may continue.
Okay, thank you, Judge. I think juror number, what was your name? 57, okay, thank you. Close to you, okay. Anybody else think of anything? Juror number 12? What? Receipt or purchase. Juror number 41, what do you think? Sure. Insurance, yeah. What about just like, not just like a car, but like any item, like your cell phone, your house? Juror number 75.
Awareness.
Awareness, yeah. Like, I think that goes back to when I was talking about the penal code. Like, it requires knowledge. You have to know that an item is in your characteristic control. Okay. Anybody else? Juror number 29.
On your person.
On your person, absolutely. So what's juror number 5?
You're the one using.
Yeah, you're the one using it. You're in the one that's in control or management of it, right? What about access? Like, if you have access to an item. Juror number 27?
If it's among your other possessions.
Oh, yeah. Like if it's mixed up with other things that you own, right? Absolutely. Okay, thank you so much, guys. Appreciate it. Okay, so I'm gonna jump to the audience for this one. Juror number. What was your juror number now? Juror number 7, let's see. Can you do me a favor? Can you take a look at that picture right up there? Okay, now, what can you tell me? That's.
Brandon, can you get the microphone?
I'm so sorry.
Can you, I mean, take.
Oh, use the pic?
Yeah.
Okay, usually I'm pretty loud. My apologies. Okay, I feel like a game show host right now. Alright. Alright, ma'am, can you take a look at that picture right there?
Yeah.
Okay, can you tell me what is that a picture of?
It's the picture of it.
Are you sure? Positive. Beyond a reasonable doubt. But I have to say, there are some pieces of that puzzle that are missing, right? So you don't have all the pieces of the puzzle together, right? But you can say beyond a reasonable doubt that that is no. So you can pull from incomplete data to make a final result. Yeah, I agree. Thank you so much. Appreciate it. And that, guys, is beyond a reasonable doubt. I can't, like Judge said, I can't give you a definition. That definition is completely up to you. It's up to you to decide what is a reasonable doubt or not. But just like this photo, I can't give you everything because that would be proof beyond all doubt. That is taking us beyond our brain. That would be unfair to us. So, like the juror said, do we have all the pieces here? No. But can you use your common sense, your knowledge, your background to be able to take from that, even though you don't have all the pieces, and say, hey, that is what it is? Can y'all do that? Absolutely. Common sense does not check out at that door. You're allowed to think when you're in the bus, and I encourage y'all to think. And so the state has the burden of proof. It's all on us. Like Judge said, Mr. Mauer and Trey can't just sit there and not do anything this entire trial. It's up to myself and it's up to Lauren to do our jobs here, to prove the elements of this case to y'all beyond a reasonable doubt. Now, the definition, we already talked about what it could possibly be. It's all up to y'all. But I can tell you what it's not. It is not beyond all doubt. It is not beyond a shadow of a doubt. It is not beyond an unreasonable doubt. It applies to all the elements of the case. And here is the big one. If the case is proven to you beyond a reasonable doubt, by law, you must convict. The only verdict you can come back with is. Don't sound too enthusiastic, guys. So if I prove the case to y'all, let's try this. Right now, if Judge asks y'all for a verdict, the verdict would be. But if I prove the case to y'all beyond a reasonable doubt, the only verdict y'all can come back with is. Perfect. So, questions to ask yourself. Do I have a doubt? Is it reasonable? And does it go to the elements of a crime? It all depends on what y'all think. So evidence. Reality versus fiction. Man, I wish it was like CSI because we have this all wrapped up in an hour. Unfortunately, it is not like that in the real world. So the reality, here's the harsh reality of it. I've had a lot of juries ask for police reports. Police reports cannot be entered into evidence. We can put them in front of the judge. I'm sorry, we can put them in front of the officer. They can use it to refresh their recollection, their memory of the event, but we can't get it in front of y'all when y'all go back to deliberate. Is everybody okay with that? Is anybody not okay with that? Okay, perfect. All right, next, fingerprints. I can tell you all this from when I was a sheriff's deputy.
Yes.
They object. have a couple of occasions. Pretty serious at that point. With my phone with my cell phone. Okay. Yes, number 5.
Yes, I had a friend who was picked.
Okay, with that, I guess with that, situation involving your friend, keep you from being fair and impartial on the case. Okay. Yeah. Number 5, she said. She was very so who decides whether or not, what facts to believe or not believe? The number, what number are you, sir?
68.
68. So who decides what facts to believe in a jury trial?
Jury.
Okay. So if you're on the jury, you're gonna decide what facts you believe, what you don't believe. Okay, anybody have any problems with that or any questions? Anybody have any questions for me? You wanna get yourself on the record? Let us know why you should or shouldn't be here. Some people want jury duty. But if you don't, you might wanna speak up and let us know about why you're not the right kind of person to be on this panel. So the judge talked about this. Yes, number 40. Yes, ma'am. Would you stand up, please? Yes, ma'am.
I'm not a foster. In the green shirt, yeah.
Okay.
Oh, that's. Years ago.
I'm sorry, I'm gonna need you all to speak up so the court reporter
He
can
was-
hear.
She said Brandon was a prosecutor on her son's case.
Okay,
All right, thank you, ma'am.
and what's your number?
40.
All right, thank you.
So, a lot of people have a thought process. If somebody's made it this far in the legal system, they're guilty, right? The judge talked about innocent until proven guilty. But some people think you made it this far, you're probably guilty, right? So who here feels that way? If you've come this far in the legal system, that you're probably guilty? No? Okay. So the judge decides what evidence to admit. Jurors decide whether or not it's true, okay? Like juror number 68 said, he's one of the experts, people who've been on criminal jury trials, and tell you, the jurors make the decision about what facts are true and not true. We talked about the presumption of innocence, and I know the judge touched on this. There is actually a case that says I can sleep during jury trial. I haven't done it yet, but technically I can if I wanted to, and the entire burden is gonna be on the state. So that's what we talk about, innocent until proven guilty. Okay? But along with that goes the right to remain silent. The judge talked about reasons defendants don't testify. There's a myriad of reasons. Their attorneys tell them not to, speech impediments, things like that. And I know when she asked the question, nobody raised their hand or anything about whether or not that they would have a problem with the defendant not testifying. But very often, people, particularly I hear a lot from parents, who say, I want to hear both sides of the story. Okay. And so that's kind of at odds with the innocent until proven guilty and the right to remain silent. So who here believes they could not render a verdict of not guilty on a case unless they heard from the defendant? I know you're out there. Juror number 6, thank you. Juror number 25. Number 52, number 50, juror number 60, 73, and 74. Did you just want to bring them up? Okay. Okay, so Brandon talked about care, custody, control, or management. And it's going to be people on the jury decide, what that is. Obviously, maybe if we get juror number 68 back on the jury, he can kind of educate everybody about how the process works. Okay, so this is how you feel about an individual's right to own or possess firearms. And there's a lot of argument back and forth about the Second Amendment. And people's right to bear arms. So what I want to get is just your general opinion about how you feel about that. So here, who strongly agrees that people have the right to bear arms? And I'm talking about people in general. Okay. Would be number 1, 5, 9, 10, 12, 13, 14, 15 through 21, 22 through 29, 32, 34, 36, 38 through 42. Thank you all. 42, or I'm sorry, 44 through 50. 51 through 54, 57, 58, 61 through 64. Thank you. 65, 67, and 68, 69 through 72, and 73 through 75. So on the other end of the spectrum, who here strongly disagrees that people have the right to keep and bear arms? I'm not talking about everybody, just the general person. I know some people don't agree with the Second Amendment. So are there anybody here who does not agree with it? Number 37. Number 55. Anybody else? The judge talked about burden of proof. We kind of started about the same time. So we used to have this great definition. And I can still remember just like she can, and then the legislature, in its infinite wisdom, decided not to do it anymore. So essentially, it is what you think it is. Okay. There was an old saying from a Supreme Court case about pornography. I know it when I see it. That's what beyond a reasonable doubt is. You know it when you see it. It's each person has their own definition and thought process, and I can't tell you what it is. You have to decide it yourself. Number 16. How long ago were you on the jury?
Maybe about,
I can't see him. He's, all right, excuse me, if you don't block him.
it's gonna be about 4 years ago.
Okay. So long after they changed the law. So y'all were able to figure it out, right?
Yes, sir.
Okay. Okay, and so what's the judge thought is my burden of proof is what? What do I have to prove? Nothing, right? All the entire burden is on the state beyond a reasonable doubt. And so the judge talked about the different standards, all the way from not guilty to guilty beyond a reasonable doubt. And then I know there's a juror number 33. You're a family lawyer, right? You're gonna be in front of Judge Kendrick? Medina?
Yeah.
He used to be a DA here. So you talked about the different burdens, right? So clear and convincing in order to take somebody's child from them, right? And the beyond a reasonable doubt is even higher. So imagine how much greater that burden is. If clear and convincing is required to take somebody's child away, right? Beyond a reasonable doubt is even higher than that. Okay. Anybody want to take a shot at kind of defining it? Give us a definition of beyond a reasonable doubt. And you get extra credit. I'm sorry, would you stand up? What number are you? Yeah, I thought there was one. Now I want to see if you have a definition. Okay. Neither does the legislature, unfortunately. Okay, so reasonable doubt can be raised 3 different ways, right? The evidence you're presented, the lack of evidence, okay, or conflict in the evidence. And that's what the people on the jury have to decide. Anybody have any questions about that or want to talk about it? Because there are a whole lot of people we haven't heard from. So I'll tell you a story. I tried a case about 15 years ago. And there was a guy on the panel, he didn't ask any questions made on the panel. The jury was out deliberating and his mom showed up. He had gotten his jury summons, snuck out of the house, came down there, and he was special needs and ended up on the jury panel, he ended up getting a mistrial to halfway through because he just sat there. So the people that sit here and don't ask questions or answer any questions are generally the people that are gonna be with us. Okay, so anybody want to say anything? I know they say the number one fear is public speaking. Oh, 61. Yes, Route 61, yes, sir.
It's not really related to that, I have cerebral palsy, wondering.
Okay. Do they prevent you from sitting on this jury?
No,
Good,
no, just letting you know.
thank you. Yes, number 34. Yes, ma'am.
I don't think it's gonna keep me from sitting on a jury, but my service dog that are here with me and be sitting on the jury.
Pardon me. So the two different verdicts are guilty or not guilty, okay? If, and anything less than beyond a reasonable doubt, your verdict has to be what? Yes, I'm sorry, yes, ma'am, this is number 32, would you stand up?
I have a question.
Yes, ma'am.
I did serve in a jury in, I don't remember if it was 93 or 96 years ago. It was the state of Texas versus a 19-year-old girl, I remember the name. And she was convicted because, it was a thing where these two groups of people were at a bar, these two groups of girls were at a bar. Somehow these two groups got in a fight. And the smaller group decided they'd had enough and they wanted to leave. And the bigger group followed them. And so, anyway, she got convicted because she ran into the driver of the smaller group, ran into the other car and ended up injuring one of the people in the other car. So, but she was the driver, she was convicted, she was 19, really bad. The question I have is, when we were deliberating that case, there was a woman that was a Mothers Against Drunk Drivers who was in our jury. And she was strongly dead set against convicting that young girl. And she went around, she wouldn't quit, she wouldn't stop. And I didn't know, because this was my first time to ever sit in a jury. I didn't think that it was fair, that she was the one that was trying to convince everybody to, you know, convict this sergeant as poor young girl. And anyway, I didn't know, how do I speak up? How do we speak up and say, hey, this is not right, I don't agree with this woman in our jury? What do we do?
Well, generally what happens in those situations, you just send a note out. Right, they'll like a four person, and then, you know, internal, there's all these things about internal misconduct and things like that, but if there's a problem, you generally send a note out.
Okay.
Yeah. Anybody else have any questions? Thank you.
All right. All right, ladies and gentlemen, I'm going to have you all step outside. Please remain outside and we'll let you know if we need to call any of you back in for any questions. You're not excused from this process. You're just excused for now from being inside the courtroom. So make sure you take your items with you and also leave the cards behind. They're very expensive. All right.
Jury room?
Oh, yeah. All right, something here, Mr. Cortez? I can hear the judge. I mean, it's like, it just lets me hear at the bench.
Yeah, that's what.
It's just loud.
Wow,
yeah. All right, are you all ready?
Oh, yes.
Court is calling 2019 CR 6016 State versus David Jimenez. Can I have parties announced?
Megan Galloway for the state.
Rafael Leal for Mr. Cortez.
And he is Cortez Jimenez, is that correct?
Correct.
And are you Mr. David Cortez Jimenez?
Correct.
All right, we have an interpreter here. If you could raise your right hand for me, please. Do you solemnly swear and affirm you will faithfully translate from English into Spanish and from Spanish to English? So help you God.
Yes, Sean.
All right, you can lower your hand if you'll state your name for the record.
Jacqueline Payan.
All right, Mr. Jimenez, all of the documents I'm going to review with you are in English. Will those documents explain to you in Spanish?
Sí.
Yes.
And Mr. Leal, do you speak Spanish?
Yes, sir.
Stamp for, please. I'm sorry. And do you speak Spanish fluently?
Yes, sir.
And were you able to explain these documents to your client in Spanish?
Yes, sir.
All right, counsel, you received all discovery. Did you review it with your client?
Yes, sir.
Court will find that the state is in compliance with discovery. Mr. Cortez, did you review the application for deferred adjudication with your attorney? Did you understand it?
Sí.
Yes.
Counsel, do you waive the reading?
Yes, sir.
Mr. Jimenez, did you review, state, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Jimenez, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Sí.
Yes.
Sorry, that you can take that thing. All right, you're charged with evading arrest, detention with a vehicle. That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in the prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call on the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yeah.
Did you understand that the court would grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine.
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, sir.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe he is and he was.
Mr. Cortez Jimenez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
No.
Anyone promised you anything other than the plea?
No.
No.
Are you satisfied with the way you've been represented?
Sí.
Yes.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes.
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Sí.
Yes.
According to the plea, there's a $1,000 fine. The state recommends deferred adjudication. They will take in consideration 2025 CC 010746. Did you understand that to be the plea?
Sí.
Yes.
Defense?
Yes, sir.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Sí.
Yes.
By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Sí.
Yes.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 3 years. There be a TAP evaluation, 100 hours of community service restitution, and the driver's safety course. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? And
Yes,
to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
no contest.
State any evidence?
State offers states one in attachments.
No objection.
All right, state you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes,
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
yes,
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
yes,
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Judge, we just like for the court to follow the agreement. My client has no prior felonies. He has some minor criminal record, but it's related to, I believe, intoxication in the past misdemeanors.
All right, do you have any children?
Sí,
yes,
What are their ages?
La más grande tiene 32, otro tiene 24, otro tiene 21, una niña tiene, un niño tiene 13 y una niña tiene 7.
The oldest is 32, the other one is 24, then the next one is 21, the other one is 13, and the last one is 7.
All right, this is what the court will do. The court is going to sentence you to 3 years deferred adjudication, regular reporting by Zoom or in person, regular random UAs. Take in consideration 2025 CC 010746. TAP evaluation out of custody, follow recommendations. 100 hours of community service restitution. I'm going to order the driver safety course. Once that's completed, 50 hours will be deemed satisfied. I'm going to order parenting classes, and the remaining hours will be deemed satisfied upon completion of parenting classes. Field visits 1 time per month for 4 months. And there's to be no driving without valid license and proof of insurance. And you'll need to provide that to probation. Probation, is there anything else? Thank you. Proof of employment within 45 days, no employment as a home health care provider or with minors. All right, is there anything else you need, Mr. Jimenez?
No estoy.
No, that's fine.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Sí,
Yes,
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
sí.
yes.
All right, good luck to you. Probation will go over conditions.
thank you, Your Honor.
Thank you.
Gracias.
All right,
Thank
let
you,
me
Judge.
know. Oh, thank you. Thank you for coming.
Yes.
Point of order.
I do that,
Oh, you did?
yeah. I said, you're paying back.
That's why I say y'all are good guys.
I appreciate that. But it's up a little bit.
Oh, no, no problem.
Oh, no, I saw this, and I was like, "Hey, that's fine."
I'm sorry.
No, ma'am, I'm
No.
almost done. Oh,
We're waiting for the,
I just want to make sure.
no, we're not waiting for you. All right, State Defense, if you can grab your strike list, and I'll review the jurors with you all so you can tell me if it's correct.